Straight ahead on Law&Crime Daily. From the Olympics to an attempted murder trial, how defendant Michael Barisone reacted moments after a near-deadly shooting.
I just appeared impartial, not excited, not upset, not angry, just sitting there.
And
I was able to hold my father's hand as he took his last breath.
the state rests its case as ex-ICU doctor William Husel stands trial for patient murder, plus the deadly Waukesha Christmas parade.
We all recognize there could be a problem in paneling the jury from Waukesha County.
How both sides work to seat an impartial jury. But first,
do you think I'm playing with you? Huh? Huh? You're a grown man, I'm a grown man. I don't like what you did.
Disturbing video shows life inside the Sarah Lawrence College cult. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmeyer along with Terry Austin. The prosecution's exhibits are showing more about what went on behind the curtain of the Sarah Lawrence sex cult, as the group's alleged leader, Lawrence Ray, stands trial on federal charges. Ray is facing several federal charges, including racketeering, sex trafficking, and money laundering, among others. It all stems from Ray allegedly starting the Ray family after he moved in with his daughter Talia's on-campus housing at Sarah Lawrence College back in 2010. Over the next 10 years, Ray allegedly used manipulation and fear tactics to gain control of Talia's college friends. His alleged victims initially saw Ray as a father figure, but those who have testified so far say they soon saw a different side of him. Cameras aren't allowed in federal court, but several publicly released court exhibits are giving more insight to the testimony and what happened over the last 10 years, including a rare one showing Ray allegedly using violence against Daniel Levin, one of Ray's alleged victims, who also wrote a memoir about his time as a Ray family cult member.
So you're trying to pull back now, aren't you?
Yeah. No, I don't. I did the comment stuff like back around the time of like the Mitt Romney blog, like way back, like months ago.
You're trying to parse again. Why can me, Tom?
I'm being honest though.
Come here, Tom. Stick it out. Stick the fucking Stick next one's gonna be the head of you. Do you understand? See this how it feels? What if I pick you up like that? Can I pick you up by your tongue? Huh? Do you think I'm playing with you? Huh? Huh? You're a grown man, I'm a grown man. I don't like what you did. You hear me? Now one more time and I'm going to split your tongue in half. Do you understand me?
Oh. Yeah. Yes.
You don't start telling the truth. I spent good money to find out these facts, you little piece of shit. And I'm telling you, listen to me. Listen to me. Don't f around with lying now. Tell the truth. Next thing's gonna be out is your f***ing balls. Did you like that the other night when your balls were getting strangulated?
No.
Huh? What should I do to them tonight?
Law&Crime's Adam Classfeld is spending the duration of this trial inside the courtroom. He has details on Tuesday's continued testimony from another one of Ray's alleged victims, Felicia Rosario.
Felicia Rosario's testimony has just started into cross-examination. The direct examination concluded this morning with a bit of a surprising allegation that goes to the money laundering count. The government claims that some of the enterprise money from Larry Ray's alleged criminal enterprise went through to Rosario, who in turn donated it to Larry's daughter, Talia Ray, who at the time was working for the North Carolina Democratic Party. So they are essentially, the government is alleging that this money passed through political donations. So that was the end of direct examination. We're starting to get into the world of cross-examination. We don't know how much longer Felicia Rosario will be on the witness stand, or whether other victims are going to testify after her. We have heard the name throughout the trial, for example, Dan Levin. We're not sure whether or not he will take the stand, but we have seen and heard much about him throughout this trial. It has been quite a journey for many of them to go from his orbit to a federal court witness stand.
Joining us today is criminal defense attorney Taylor Koss and Terry Austin to break down the latest in the Lawrence Ray sex cult federal trial. Taylor, money transferring over state lines connected through political donations. Does Rosario give the government everything they need for the money laundering charge?
You know, it's interesting that we're talking about money laundering after we see those highly disturbing videos of what went on at Sarah Lawrence and the years after. You know, the array of charges against Ray are troubling and seem to be far more serious than money laundering. However, having said that, I think it is interesting, this development, that Felicia was essentially taking profits from the criminal enterprise and funneling them down to the North Carolina Democratic Party via Ray's daughter. And so I think her testimony is key and essential to the money laundering charges. And I doubt that without her testimony, those charges would ever have been brought against him. So she is certainly the linchpin with regards to those specific charges.
Absolutely. Now, Terry, do you get a sense the prosecution's case is coming to an end? Also, my guess is Ray never takes the stand. I think he'd be absolutely destroyed on cross-examination. What do you think he'll do?
Listen, I think the jury is hoping the case comes to an end. It's been several weeks already, and we've had several witnesses who were victims, and their testimony has been riveting. And as we've been talking about, these videos are so damaging and very difficult to listen to. So I am certain the jury does not want to see more of that. As far as whether or not the defendant, Lawrence Ray, is going to take the stand, I cannot imagine. Of all cases, this is the very case where he should not take the stand. There is absolutely no way he can explain what goes on in those videos.
All right, we'll see how it continues as we get more from Adam Classfield and updates in that case. Switching now to South Carolina, where disgraced attorney Alec Murdaugh confesses to scamming the family of his late housekeeper out of millions of dollars in an insurance payout. Murdaugh now admits he swindled the family of his housekeeper, Gloria Stattersfeld, who died on his family property back in 2018. At the time, Murdaugh suggested Statterfeld's son sue him for insurance money to create a greater payout. Statterfeld's family says they never received that money, and Murdaugh now admits he kept it for himself. He's now asking the court to uphold the order to pay back the Statterfeld family $4.3 million. All this is just the latest twist in the so-called Murdaugh murder mystery. Murdaugh made national headlines in June of last year when his wife Maggie and son Paul were found murdered on the family's property. Months later, Murdaugh confessed to orchestrating a botched suicide for hire plan in hopes of leaving a life insurance policy to his remaining son. And in national news, a federal judge rules that former President Donald Trump most likely committed felonies in an attempt to overturn the 2020 election. Trump's lawyer, John Eastman, is now ordered to turn over documents that have been withheld from the January 6th committee. Trump and Eastman are accused of obstructing the work of Congress and conspiring to defraud the United States. This as White House records from January 6 are turned over to the House Select Committee, showing a nearly 8-hour gap in Trump's call log. That means there are no records of the calls made by Trump during the insurrection of the U.S. Capitol. The House committee is now investigating whether Trump communicated via back channels or burner phones during that time. Still ahead on Law&Crime Daily, after weeks of witness testimony, the state rests its case in Ohio versus William Husel. But first, the deadly crash at the Waukesha Holiday Parade. Is it possible to seat an impartial jury? Welcome back. The man charged with crashing his vehicle into a Wisconsin Christmas parade appears in court on Tuesday as both sides work to secure an impartial jury for the upcoming trial. Darrell Brooks faces 83 charges in connection to the November 2021 crash in Waukesha, Wisconsin. Prosecutors say Brooks crashed through barriers and drove into the parade, killing 6 people and injuring dozens others. Earlier this month, a Waukesha County judge set a trial date for October, saying the months leading up to the trial should be spent working to secure an impartial jury. Prosecutors suggested a jury questionnaire should be sent out in April, being that many people in the county were either at the parade, know someone who was affected, or donated to support funds for those affected. While the defense motioned for a new venue and indicated it would not be ready for an October trial, but the defense still agreed with the judge and prosecutors that a jury questionnaire should be sent out in the next week. Back with us is criminal defense attorney Taylor Koss and Terry Austin as we look ahead to jury selection for the deadly Waukesha parade crash. Taylor, I doubt they can find an impartial jury in Waukesha, but how far is far enough to find an impartial jury in Wisconsin?
Yeah, Brian, in my opinion, Waukesha is a total and complete non-starter. There's no way they can get a fair jury there. This is small town USA, terrible, big, huge incident, had the eyes on it from almost everyone in town, and somebody is connected. So the question becomes, in this day and age, how far is far enough? It used to be where you could go to a town, maybe 20, 30 miles away, and you'd be fine. But with the internet and 24-hour news cycle, it becomes harder and harder to find a fair venue with regards to cases that are the focus of the press. So I would say on something like this, you need to go at least 2, 3, 4 hours away to even attempt to get a fair jury. But this is going to be a struggle for them. It's going to be tough.
Yeah. Now, Terry, can you give us an example of the type of questions Brooks' defense may want for a case like this in their questionnaire?
Well, I think that questionnaire is going to have to be detailed and it's going to have to be clear because we know in other juries, it's not clear what you're talking about and they're going to want answers. So for instance, are you a victim of a crime? Define what crime is. So it's very clear whether or not you were a victim of a crime. And I think the defense is going to want to know that because those people will be less sympathetic. On the flip side of that, the defense is going to want to know whether or not you've been accused of a crime. We know for a fact that Brooks has in the past been accused and convicted of various crimes. So we want to know that for the defense. And then I think mental illness, that might be an issue here. They're going to want to know if anyone has ever suffered any mental illness.
Yeah, especially that last one, because I'm still racking my brain to see what the possible defense is going to be here, or if this is, and pardon the term, just a very slow plea towards a guilty verdict. But of course, we'll give you updates as this case eventually starts, probably months from now. Coming up on Law&Crime Daily, a closer look at the moments following the shooting of Lauren Canorak. We head to New Jersey for the Olympian attempted murder trial. Plus, the state rests its case in the trial of ex-ICU doctor William Husel. Was it murder or patient care? Welcome back to Law&Crime Daily. The state rests its case in the trial for former Dr. William Husel, a former Ohio ICU physician on trial for the murders of over a dozen patients. Prosecutors allege Husel prescribed excessive amounts of fentanyl to 14 of his patients while they were being treated at Mount Carmel Hospital from 2015 to 2018. His defense team argues he was simply giving end-of-life comfort care. Prosecutors called medical experts to testify, and Husel's former co-workers, including pharmacists and nurses who worked alongside the former doctor. Prosecutors also called family members of Husel's alleged victims, sons and daughters, among others, who lost a family member under his care. Many of them testified about conversations with Husel, learning that their family member was dying and having to make the difficult decision to take them off of life support. The prosecution's final witness was a son of a patient. He lost his father after complications from a lesion on his foot and toe amputations.
What did Dr. Husel tell you during this up?
Again, he said that my father's organs were shutting down, the lactic acid was building up in his body, and that he was potentially brain damaged or dead. As the situation never changed at that point, and he came to us later and he said we might want to consider removing him off of the ventilators. Later on in the evening, I'd say probably around 8 o'clock, after Dr. Husel approached me, we had a family meeting to decide whether or not to remove him off of the machines.
And what information, if any, were you relying for this family meeting? Whose information were you relying on?
On the information that Dr. Husel provided us.
Criminal defense attorney Taylor Koss and co-host Terry Austin join us again as the prosecutor rests and we look ahead to what's next for Husel's trial. Terry, the defense is going to ask for a trial order dismissal. It happens all the time. Now that the prosecution is rested, why do you think they'll lose that motion?
Oh, they will definitely lose. Those types of motions are rarely granted by the judge. You have to prove that the prosecution failed to produce enough evidence or claim that the prosecution failed to produce enough evidence to support a guilty verdict. But here there's plenty of evidence. They have multiple witnesses, they have multiple experts who've all said that Dr. Husel over medicated and caused the death of their family members. But frankly, Brian, I think we have evidence on the other side too. So this is definitely one of those cases that should go to a jury to determine which side is more accurate here. I don't think it's going to be easy, though.
Yep. Now, Taylor, why did he do this? This seems to be the major question still left on the table in this trial. Do you think Husel on the stand could lead to an acquittal?
So the only way we will ever know why, we know the what, we know the where, we know the how. The why can only come from the doctor himself. I think he testifies, and I think it's probably the only way he has a chance of an acquittal here, because this is a case that is just wrought with emotion. The situation that we just heard the witness on the stand going through, those last emotional moments of a relative, a family member, a loved one's life, many, many people have gone through that. And it's likely that many members of the jury have gone through that. If the doctor could get on the stand and explain that during that, of the ultra most sensitive moments, he was only trying to ease the pain of his patients and guide them to the next portion of their life. Perhaps the jury will sympathize with that and realize that this is not a criminal, just a doctor performing his duty.
Yeah, a full acquittal is still a home run, very hard to get, but 2 or 3 jurors sympathizing with the defense in this very difficult decision, I think it could actually have a hung jury and maybe find him not guilty in this case. But of course, we'll keep eyes on this case as it develops. When we come back, a one-time Olympian is now on trial for 2 counts of attempted murder. Still ahead, the first witness is called in the state of New Jersey. First, Michael Barisone. Welcome back. We're getting a closer look into the mind of defendant Michael Barisone, the one-time Olympian now in charge with 2 counts of attempted murder. A psych evaluation released by the defense says, quote, at the time of the shooting, Barisone was severely psychotic. This echoes the defense's opening statement on Monday, where attorney Edward Belinkis told jurors that his client had a history of abuse and mental health issues. Prosecutors say Barisone knowingly shot Lauren Canarak back in 2019 and attempted to shoot her boyfriend, Robert Goodwin. Leading up to the shooting, Canarak and Goodwin lived on Barisone's property. At the same time, Barisone was training Canarak in dressage riding. Before the shooting, a string of 911 calls were made by both parties. Barisone saying he tried to evict Canarak and Canarak saying she was being harassed. Barisone was arrested after he shot Canarak in the chest and fired another shot at Goodwin. As Goodwin struggled with Barisone, Canarak called 911. On Monday, the prosecution called his first witness, a corporal who responded to the 911 call and shooting.
Do you recall whether you overheard him making any statements during the time you were in his vicinity?
Yes, I did.
Can you tell the jury what you heard those statements to be?
I had a good life.
Now, do you recall whether the defendant said that once or more than once?
Multiple times, maybe 2 or 3 times.
And you just said that he stated, I had a good life. Was that a verbatim statement, or is that a summary of what you recall him saying?
That's what he said.
Were those statements made in response to any questioning by you?
No.
Can you describe the defendant's appearance or demeanor at the time that he was making these statements?
I just appeared impartial, not excited, not upset, not angry, just sitting there.
Did you have any issues understanding the words that he used?
No.
Taylor, in the prosecution's opening, they said the alleged victims in this case, Canarak and Goodwin, may have done things the jurors may not like. What do you think that could be, and why bring it up in openings?
So you bring it up in the opening because, so if you know it's going to happen and you know it's coming, what you want to do is you want to take the sting out of it right away, right from the beginning. No surprises, no points for the defense. If you know that something negative about your witness is going to come out, you want to be the one to be the first to tell the jury. Now, in this case, since they didn't mention any specifics, it seems to be that while they think there might be some bad things coming out, they might not know A, what specific things are coming out, or B, what rulings the court is going to make to allow them to come back. But we have heard that Barisone has reportedly called the police several times, tried to have the victims evicted from the property, and also claimed that they threatened him and attempted to damage his property. So it could be along the lines of some of those things.
All right, we'll see how the testimony rolls out. Terry, the defense gave a fairly detailed opening statement. Do you think he has planted seeds of reasonable doubt so far?
Absolutely. I listened to that prosecution and I was thinking, okay, this is a done deal. I listened to the defense and there is reasonable doubt. That opening was very detailed. And in fact, Taylor is talking about some of the details that actually came out. I think they're going to claim, both self-defense and both mental illness. And they established during that opening statement that he was being harassed by Lauren Kinerick and that the boyfriend was also harassing him. He called 911 4 different times. He said he was in fear of his life. And then on a post, she actually said that he had sex with a child. So yes, I think good defense.
All right, we'll see as the testimony rolls in this case. Thank you both, and thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.